Thank you very much, dear colleagues. First of all, I would like to express my feelings. I am so happy to be there with you at the building of this academy. This is a pleasure because, first of all, I can meet again colleagues and friends, namely the two colleagues I had just in the opening panel. And yes, I can create some difficulties because of the language I use, because I was speaking French, but I think it is important for me to be there. Why? Probably this is one of the very few places where we can ask very important questions, so important for the future of the European Union. It is not important to say, I accept everything which is told or which is asked or answered. But the most important thing is to ask the good questions, because these questions are rarely on the table. So that is why I'm grateful to be there. And I am so happy to be able to put also my questions on the table. So if this meeting is devoted to the nature of the European Union and the question of its evolution towards a form of a somewhat shameful, for at least implicit federalization, one of the keys to analysis is to note, and this term has been already used, is to note how the European Union uses integration mechanisms that go beyond what results from a strict interpretation of the treaties. From this point of view, references to the rule of law as well as to the values of the Union are particularly effective instruments. The European Union is really seeking for these effective instruments. And the European Union is seeking to define its identity, namely by referring to the values on which it considers to have been founded. But in fact, the reference to these common values, of which the Court of Justice is the guardian, is a very effective tool for integration that goes far beyond the goals of the Union and contributes to the generation of conflicts between the Union and certain member states that wish to assert their own identity. First of all, what are these values as markers of European identity? Values, so-called values, into brackets. Despite claims to the contrary, the European Union is not a legal order founded on the democratic principle. I will not go into the details here, but this is a legal assessment that does not in itself entail value judgment. Since it cannot find its justification in competences that are essentially economic or financial nature, the European Union refers to values that are supposed to constitute its identity. As there is no demos, the Union refers to the abstract universalism of fundamental rights. Article 2 of the treaty thus refers to a list of principles with a number of characteristics. On the one hand, it refers to rights that form the basis of the common values of Western states, in particular dignity and freedom, to which are added specific rights such as minority rights and those related to non-discrimination and tolerance. If in principle, these values can be considered as consensual. They are much less so when it comes to putting them into practice. We can ask the question, how to articulate universalism and minority rights, non-discrimination and differences between nationals and foreigners, the non-Europeans, traditional values and specific recognition of sexual minorities, and I could continue the enumeration. The second characteristic is that it articulates undefined principles of a different nature. What concept of the rule of law does this text refer to? A substantive one, formal one, strict one, broad one? And who defines what it covers? Are dignity and freedom distinct from human rights? How do freedom and dignity relate to each other? Finally, it is postulated that these values are common to the member states. While it may be considered that sharing these values is a condition of membership of the Union, the fundamental question is the following: whether the member states should be presumed to have accepted any constructive interpretation that the Court of Justice may give to them as regards their definition, their scope, and their articulation. This form of legitimation comes up against a question of embodiment. The question is the following: does a political project can be built without history, myths, and symbols or not? The choice not to refer to Europe's Christian roots, a purely descriptive statement that did not preempt the place of religion in the European legal order, is not really counterbalanced by the existence of an anthem or a flag. Finally, this process is indicative of the fact that the European project aims to build a nation, a demos, through law, and not to develop a law that the demos would give himself. There are even more obstacles, namely the principles and values to which reference is made are, if not universal, at least they are intended to be. In the Western imagination, those values are supposed to be shared by every political society, whatever its history, geography, or ethics. They are, moreover, exactly the same values which are affirmed within the framework of the Council of Europe. The question that we should then ask is how it is possible to conceive of a European identity based on or around these values. This situation is exacerbated by the fact that the scope of the values referred to owes little to determination of these values by political bodies, but on the contrary are the fruit of an apolitical or at least an ademocratic bodies such as the European Court of Human Rights and the Council of Europe's Venice Commission. Moreover, the NGOs whose membership of civil society serves as a patent of legitimacy are not subject to any obligation of transparency and pursue specific and diverse interests, play a significant role, accentuating a communitarian conception of recognized rights that further blurs the lines of identity. The result is that history and culture have to take a backseat. What matters now is loyalty to rights and procedures, and attachment to the rule of law and the welfare state. Thus, in a caricatural way, the structuring of the Union can only be achieved by destroying the singularity of its member states, nothing less than the very core that justifies its existence. And yes, if we deny the identity of nations, well, we will deny the reality of those states. What a state does mean without any national identity. And let's now speak about the Union's values and as an instrument for extending its competences. Among the Union values, the concept of the rule of law, a concept that has come to play a strategic role both in legitimizing regalian functions and in legitimizing the attacks made on national sovereignty by the European institutions. In Yes, we've got this very difficult procedure, Article 7, difficult to implement. We've got that, but in addition to this procedure, there is now a simpler and more effective procedure that has been implemented in order to enforce compliance with the same principle outside the provisions of the treaty. It's particularly topical and aligned with budgetary and financial federalization. Uh, I do think these are really budget and finance tools of federalization, so it makes aid distributed under the recovery fund conditional, namely in compliance with the rule of law, enables and this enables the Commission in the event of a breach of the rule of law likely to affect the management of the funds of the Union's financial interest to deprive the so-called guilty states of aid under the European Recovery Plan. These include the fundamental values of the Union, including the independence of the judiciary. The procedure has its origins in a resolution of the European Parliament, which considered the following to be breaches of the rule of law, and I quote, attacks on the freedom of the media and journalists, migrants, women's rights, the rights of LGBT people, and freedom of association and assembly. An objective reading would suggest that those criteria are far removed from any requirement of a sound management of a European fund. More serious is the argument relating to the proper functioning of the justice system. It is this issue that lies at the heart of the decision of the 16th February 2022, in which the Court of Justice of the European Union rejected the appeal by Poland and Hungary against the sanction mechanism, which empowers the Commission to suspend aid to member states that do not respect the so-called values of the Union. This decision should be analyzed in some details, given that the Court's reasoning suggests an extension of the Union's powers. I won't go into the details, but I would like to speak about it because I think it is really a showcase of federalization. The Court postulates that, I quote, once an applicant country becomes a member state, it joins a legal construct based on the fundamental premise that each member state shares with all the other member states and recognizes that they share with it a set of common values on which the Union is founded, as set out in Article 2 of the treaties. Consequently, the rights and practices of the member states should continue to respect the common values on which the Union is founded, no doubt. The scope of these values is particularly broad. Where is the problem? There is a very broad list of authorities who can define what rule of law is and what it is, the definition. This is a big problem. Rule of state, it's good for everything, but who can define it? So, according to the court, in order to ascertain whether the requirements of the rule of law are met, the court takes into consideration a very broad list of authorities empowered to define what falls within the scope of the rule of law, which highlights the potential indeterminate and extensive nature of the concept. So there is also regulation possible. So encompasses the principles of legality, legal certainty, prohibition of arbitrary action to be executive, effective judicial protection, separation of powers, non-discrimination and equality before the law. So in addition to this definition, which refers to a concept which may be accepted by consensus, according to which the rule of law is in fact protection against arbitrariness, the court validates an extensive concept adopted by the contested regulation, according to which, for the purposes of applying that regulation, is to be understood in the light of the other value and principles of union enshrined in Article 2. And yes, we've got other very important question, the non-discrimination one, but the law is discriminating all the time. because we've got nationals and non-nationals, we've got friends and enemies. So what we have to see is that it is legitimate to have some kind of discrimination. We've got all kind of discriminations on ethnical origins and so on and so on. Yes, it's not acceptable, but non-discrimination cannot be a general one, because every single law, whenever there is a rule applying for category, discriminates. So every rule is discriminating. Okay, it's a caricature, I know, but it is somewhat like that. So it's rule of law, it is just the basis of intervention by the European institutions and a tool. After basing the Union's competence on the institutional organization of the state, the Code sets aside the reservation linked to the respect for the state competences relating to their constitutional structure, thus making the subordination of the constitutional law of the states, both in terms of the interpretation of common values and with regard to institutional issues, to the principles and defined beforehand. And it is something very interesting. Why? Because if we start with values, and there will be a step in by the EU in fields normally preserved for the member states. Approved by the Council in June 2022, the Polish plan requires not only that the disciplinary system for judges should be transferred to another body and that the right for Polish courts to submit preliminary questions to the Court of Justice of the European Union be implemented, but also an improvement in legislative work, in particular through the introduction of public consultations and the limited use of accelerated procedures in Parliament. And there is also a proposal of the Commission to harmonize rules of private international law relating to parentage EU level. For example, it should be noted that this proposal is one of the key actions mentioned in the EU strategy for children's rights and equal treatment for LGBTQ persons. For example, recognition of the civil status of children born through surrogate motherhood is becoming the norm, even in countries that consider their surrogate motherhood contrary to public policy. Now, in November 2023, a proposal for a directive from the Council and Parliament aims to counter strategic lawsuits that distort public debate, known as gagging procedures. The aim is to prevent those most exposed to attacks by the media, politicians and litigants, business leaders, public officials, public political parties, companies, government bodies themselves, from seeking justice for slanderous accusations when the perpetrators present themselves as defenders of human rights. In other words, according to the text, any individuals or organizations engaged in the defense of fundamental rights and various other rights, such as environmental and climate rights, human rights, the rights of LGBTQ people, the rights of people from racial or ethnic minorities, workers' rights, or religious freedoms. One of the privileges that there are organs and bodies can be attacked based on specific procedures. So one of the privileges that often powerful NGOs will be able to enjoy now is the reversal of the burden of the proof. So, the reversal of the burden of the proof, it will be up to the applicant to demonstrate to the judge the seriousness of his or her action. In addition, if the judge deems the appeal by the powerful party to be unfounded, the latter will have to reimburse legal fees, travel expenses, medical expenses, or psychological support, and compensate its detractors for damage to their reputation or emotional distress linked to the legal proceedings. It also faces is effective, proportionate, and deserves sanctions. In addition, NGOs not involved in the case will be able to intervene in the proceedings in support of the defendant. This is an example I know I really analyzed into details. But this is how values now are, let's say, functioning. In the name of the values supposedly defended by the accuser, this measure unquestionably undermines the right to an effective legal remedy and violates the principle of equality before the law, which prohibits discrimination between good and bad litigants. So, this is where plasticity of values can lead us. It is thus on the basis of rather vague concepts that legal scope of which is largely indeterminate that the bodies of the Union, and in particular the Court of Justice, intervene outside the scope of the treaty to impose on states both respect for certain values, sometimes alien to their own identity, and methods of institutional organization falling within the scope of their sovereignty. One of the solutions I recommend is to move from an obligation to submit to an obligation to engage in dialogue on this issue. Yes, we are legal experts. We can have great conclusions, but what to propose as a solution? So one of the solutions I would like to recommend is really this obligation to submit to a dialogue between the European Union and the member states. On the 8th May 2020, the Court of Justice of the European Union reminded the Karlsruhe Court that it alone was competent to determine whether or not an act of an institution of the European Union was contrary to Union law. In this way, the Court plays the role of a federal Supreme Court responsible for giving a final ruling on the division of powers between the member states and the Union. The European Court thus imposes a hierarchical relationship between union law and national law, including constitutional law. The United States give us a completely other example, but it is not applicable in the European Union. Dialogue. So dialogue. What is the problem? So we've got several difficulties to face, namely how to place competences. So it is a national judge saying what it is national competence. So it has ruled that as long as the member states remain the master of the treaties, the democratic legitimacy and very existence of the union rest on the authorizing law adopted by Parliament. Consequently, when a union act is adopted outside the scope of the powers defined by the authorizing law, there is a problem. For example, it's important that, for example, national courts should be able to ask questions about it. It is also very important that the composition of these organs and bodies should be changed. So, but we could imagine, for example, that in relations between courts, national courts could question the European courts again when a conflict arises or is likely to arise. We could also envisage the creation of an ad hoc conciliation body with a flexible operation, a sort of court of conflicts made up of representatives of the Supreme Courts of the state concerned and European judges responsible for settling conflicts of jurisdiction. However, if the conflicts are not resolved or if the state concerned considers that the solution to the conflict runs counter to a fundamental principle recognized by its constitutional order, the political authorities should be given the final say in the matter. So not only we should find solution mechanisms, but we cannot leave to the only solely judge to settle the problem. In France, we used to talk about dialogues of judges. They think that they can solve all problems, but now we've got a fundamental question: what democracy is and why there is a crisis of democracy. The political power has lost its real power. National, supranational judges are now those having the most power, but the citizens should have it. Thank you very much.